Our first speaker is Mr. Joseph Berra, the Director of Human Rights in the Americas Project with the Promise Institute for Human Rights at UCLA Law School. In the past, he has researched and taught interesting topics such as international human rights, immigration rights, and the rights of Afro-descendant and Indigenous people in the Central America. So he coordinates projects with organizational partners in the US, in Latin America, to engage students in human rights advocacy and the Inter-American System for Human Rights. So before entering academia, Mr. Berra was a successful civil and human rights litigator. He was also the past executive director of the Caribbean Central American Research Council and currently serves on the CCARC Board. So in addition to his law degree, Mr. Berra holds a master's in social anthropology at the University of Texas at Austin and a master's of divinity at the Universidad Centroamericana, UCA, in San Salvador, El Salvador. Let's give him a warm welcome.
Thank you, Amy. First of all, let me thank Future Lawyers and the organizers of this event for inviting me, and in particular, Amy Lee and Lauren Cook for their attentiveness and excellent work with all of the presenters in preparing this event. Let me begin by, first of all, saying that UCLA School of Law acknowledges the Gabrielino Tongva as the traditional land caretakers of Tovaangar, which is Los Angeles Basin and the South Channel Islands. We are a land grant institution. And this is interesting because it kind of folds into my presentation. For those of you who don't know, the Morrill Act of 1861, I believe, what it did was, in order to establish higher institutions of education, it gave federal lands to state higher ed institutions in order to develop their university system. But those federal lands were lands essentially stolen from Native peoples here in the United States. So we owe a debt to those Native peoples, and those of us who are in these institutions and who are privileged to study here should understand that there is an ongoing debt and reparation that needs to be applied for Native Americans who have basically helped to set up this system through the lands that were taken from them. I am truly excited about the theme chosen for this conference, Be the Change. My passion, like the theme of this conference, and the reason I myself got into law, is social justice and transformative change. As a mentor of mine once said, life has many twists and turns. Unlike many of you, I came to the legal profession later in life, in my 30s, after working with community-based movements in Central America as a member of the Jesuits, a religious order, and after I did graduate studies in anthropology. So I brought to my study of law a lived experience of the struggle for human rights and a commitment to working with others to be the change for a world more human, more just, and more in consonance with and respectful of our non-human relations, that is the natural world and our Mother Earth. Your lives will also take many twists and turns, but I hope wherever you find yourselves, whether in the legal profession or not, you sustain a passion for a world more human, more just, more in line with our non-human relations, and a commitment to be the change for our world. Tremendous challenges face our world and the human community, and your generation will be a generation of radical change. I'm not sure what advice to give you, but I do know that young men and women like yourselves, that young men and women like yourselves have visions, and old ones like myself have dreams. So I hope for you to have powerful visions, and that we elders continue to dream so that we might be the necessary change in our moment of history that, following the tradition of Native American peoples, sees 7 generations into the past and builds for 7 generations into the future. As you build your enthusiasm for the law and prepare as future lawyers, I would encourage you to develop a critical perspective on the law. You obviously want to acquire the tools necessary to practice law and the profession, but it is also necessary to understand how the law works in society, how it evolves, how it is itself a site of struggle. The law itself is a tool. Some of my colleagues here at UCLA are leading scholars in the school of thought known as critical race studies, which, at least here now in the United States, has become used as a new whipping post for the far right, even though they have little understanding of what it is or does. Professor Kimberly Crenshaw says, critical race theory is a legal study of the ways that race has been created, embedded, facilitated, and in many ways insulated by law. The law has not operated as a neutral referee, if we think of Lady Justice with the blindfolds and the scales, but instead has played a role in sustaining the institutions such as slavery, Jim Crow, racial discrimination, and even worked to define race in our society. She gives us one example of the critical study of the Tulsa Massacre a century ago. A critical perspective would look at how the law was mobilized in that event, in the deputizing and arming of white citizens, in the rounding up and internment of survivors and pressing charges against them for inciting the violence, in the failure of the legal system to indict or prosecute anyone responsible for the massacre. Similarly, in another example, the doctrine of discovery was a mobilization of the law and creation of legal principles to justify the dispossession and extermination of indigenous peoples by colonial powers and states, and was deployed by Chief Justice John Marshall here in the US and the Supreme Court in the trilogy of cases that defined the current relationship of the United States to Native nations. We have to look honestly at how the law has been used as a tool to sustain oppression and inequality. We have to be constantly challenged by the radical words of Black activist Audre Lorde, who said, "The master's tools will never dismantle the master's house." It's a challenging statement for us who are as lawyers. But I do believe the law can be a tool to achieve social justice. We live in a world governed by legal structures. So obviously lawyers are needed in the struggle to be the change we need in the world. It is good to be passionate about the law and to use the law in our struggles for transformative change and social justice. But it is a tool. It is not only the tool to achieve social justice. It is not the only tool to achieve social justice. I better stop here for a moment. I have some construction going on in the background. Can you hear me all right, is my question? Amy?
Yeah, we can hear you just right.
Okay. I think it'll be over in a minute. I've asked them to try to reduce the noise as possible, fixing our air conditioner. So it is good to be passionate about the law, to use the law in our struggles for transformative change, but it is a tool. It is not the only tool to achieve social justice, and sometimes not the best tool at that, but it is a tool nonetheless. And as lawyers, we have to live with the tension of a critical perspective on the law while maintaining our passion for social justice and our belief that our legal work can be transformative. The area of international human rights itself is not immune to these tensions, but it holds potential for accompanying the struggles for a more just world. It is a relatively young body of law, still flexible and evolving. I like to distinguish between the human rights frame and the human rights horizon. The frame is the structure that has developed in the area of human rights, the human rights instruments, the treaty bodies, and the institutions formally representing this field of law. The human rights horizon is more dynamic and emerges from the struggle of impacted communities whose humanity has been denied. While some might place the origin of human rights law in Enlightenment thinkers and liberal political philosophy, I like to see its true source as emerging from a place of non-being, from those whose humanity here has been or is denied. I see the roots of human rights in the abolitionist movement, for example, in the struggle of indigenous peoples and First Nations to assert their dignity and sovereignty, or the struggle by survivors of genocide to ensure that we never forget those episodes in human history and that they are never repeated. The struggle of women, people with disabilities, and the LGBTQ community, whose full humanity has also been denied. The Human Rights Project emerges from the passion and moral outrage needed to refuse to accept, on the one hand, man's inhumanity to man, or humanity's inhumanity to other humans, which asks us to look at what it means to be human and to define or redefine our humanity and be the change that creates a more just, more humane world. And of course, today, part of that realization of our own inhumanity lies in our relation to the non-human world. That as well, that our humanity is interconnected and not separate from the natural world. And therefore, the change and healing that needs to occur in order to realize our fullest humanity is one that involves nature and our relationship to nature as well. These struggles reveal the horizon of human rights, of what it means to be human, and they inform and shape the evolving human rights framework. My work in the field of human rights as a human rights lawyer and advocate is based on developing collaborative relationships with communities in struggle for their human rights. I try to practice with my students on our projects a form of movement lawyering, which is lawyering that accompanies social movements. The lawyers are not the protagonists in this model. The law is not the only tool to be used, and we work together to produce the knowledge and strategies that inform the movement and work for social change. An important virtue in movement lawyering is humility. My work in Honduras is based on relationships I started when I worked there as a Jesuit in the 1980s and subsequently as a lawyer in the last 20 years. With my students at an elite law school in the United States, I am aware of my privilege and social positioning. One critique of the human rights world is that of the savior mentality, that human rights operates on a paradigm of saviors, generally human rights activists from the global north, seeking to save victims, people of color in the global south, from savages in the global south. Again, it is one of the critiques we need to be aware of. The corrective to this paradigm is humility and solidarity. It is recognition of the agency of impacted communities and aligning with those communities and their goals in the struggle. It also involves the ability to critique the structural causes of the human rights violations we seek to remedy in order to effect transformative change. That critique is carried out with the impacted communities and their knowledge and experience. My work is therefore based on sustained relationships with these communities and human rights activists there. Since they also have their own lawyers in Honduras, our work is primarily one of support. It also involves bringing human rights home. We have an ongoing project to analyze and critique US foreign policy and its role in creating and sustaining the human rights and humanitarian crises in Honduras. I also carry out human rights projects with organizations here in Los Angeles, such as the Immigrant Rights Movement and the Indigenous Education Now Coalition. We generally work within the Inter-American System for Human Rights, which is one of 3 regional systems of human rights, including the European and the African systems. The Inter-American System is a product of the Organization of American States and is based on a number of treaty instruments which created the bodies and institutions of the system. The instruments include the American Charter, the American Declaration on Human Rights, the American Convention on Human Rights, the Protocol of San Salvador on Economic, Social, and Cultural Rights, and other more discrete human rights instruments such as the Conventions Against Torture, Violence Against Women, the Elimination of Racial Discrimination, the Rights of People with Disabilities, and the Declaration on the Rights of Indigenous Peoples. The principal structures of the Inter-American system are the Inter-American Commission on Human Rights and the Inter-American Court of Human Rights. The Commission has a broad mandate to promote human rights in the hemisphere and conducts site visits, country reports, and thematic reports on human rights in the Americas. It also receives complaints from civil society and civil society organizations for violations by states of their human rights. Thus, it is one way to hold states accountable for their human rights records. Now, it's important here to note that the United States and Canada are subject to monitoring and accountability by the Commission under the American Charter and the American Declaration on Human Rights, but they are not signatories to the American Declaration on Human Rights, which is the principal instrument that the Inter-American Commission and the Court monitor and enforce. And they do not recognize the jurisdiction of the Inter-American Court of Human Rights. But still, it is a means to holding them accountable, for example, for child detention at the border. There have been hearings at the Inter-American Commission on those types of violations, but very little impact in terms of changing US policy in that regard. If a complaint brought to the Commission is not resolved through a friendly settlement or adoption of measures by the state, then the Commission can take the case to the Inter-American Court for Human Rights if the state has accepted the jurisdiction of the court. The court is the ultimate authority for interpretation of the human rights instruments and for adjudication of contentious cases. While the enforcement power of the court is weak, admittedly weak, one of the downsides of the system, its jurisprudence has had a profound effect on the human rights struggle and a growing influence in Latin American judicial systems. As a structure, the Inter-American System for Human Rights has shown to be remarkably flexible and progressive in developing the human rights frame. The court and the Commission understand their roles as incorporating and defining the evolving normative structure for human rights. For example, in a landmark decision in 2001, the court incorporated the emerging framework on the rights of indigenous peoples into the Inter-American system in the case of Aguas Tigni versus Nicaragua. There, the court used Article 21 of the American Convention on Human Rights, which basically protects property rights in a liberal regime, to incorporate collective property rights of indigenous peoples as articulated in Convention 169 of the International Labor Organization on the Rights of Indigenous Peoples. And it has further incorporated other instruments like the UN Declaration on the Rights of Indigenous Peoples into its jurisprudence. It also has recognized, for example, the right to a healthy environment. And in a consultative opinion, OC 2317, even recognized the legal personhood of the environment as worthy of protection. Especially in Latin America, the jurisprudence of the court and the Inter-American system are being used to struggle for human rights within domestic courts. In those systems, treaties, and particularly treaties on fundamental or human rights, have the same rank as the Constitution. And where the state has accepted the jurisdiction of the court, its rulings are binding on human rights matters. I believe it's up to 24 states are signatories to the American Convention, and I think 18 of them have accepted the jurisdiction of the court. In Honduras, we have worked with community partners and movement lawyers in their struggle to resist the development of extractivist industries on indigenous territories and communal lands. This includes primarily the construction of hydroelectric dams, which have harmed the environment, contaminated community drinking water, and violated rights to consultation and to territory. We have helped prepare human rights complaints in Honduran courts and briefs to the Honduran Supreme Court using international human rights jurisprudence. This includes accompanying communities, the communities of Papuiles, Quilamito, and Rio Blanco specifically. These dam projects that I just mentioned in these communities are currently stopped, thanks to the efforts of the communities to halt the dam construction. However, the concessions of the rivers to these companies seeking to build the dams have not yet been revoked. It's interesting to note that recently the US government withdrew its funding for the Quilamito project, a small victory in that case. Rio Blanco is a Lenca community on the Gualcarque River. Some of you may be aware of the indigenous environmental activist Berta Cáceres, who was assassinated in March of 2016 because of her leadership of the Lenca organization COPIN and its resistance to the hydroelectric dam project being built by the company DESA, Desarrollos Eléctricos. We worked with COPIN, the community of Rio Blanco, and their attorneys in a field experience with students to collect testimony from community members on the aggressions against the community and to research and document the community's title to the land. We filed an expert brief on the violation of the right to consultation in the dam project and support their efforts to gain title to the land. For the past 3 years, on behalf of the Promise Institute, I have been part of an expert international observer mission to observe the trials of the assassins of Berta Cáceres. The demand for justice in the Berta Cáceres case is an example of human rights in action and an ongoing effort led by the family, COPIN, and the community of Rio Blanco, their legal team, and a domestic and international social movement in solidarity with them. This past Monday, an historic verdict was rendered in a Honduran criminal court, finding the president of DESA, Roberto David Castillo, guilty as a co-author of the crime of assassination of Berta Cáceres. Previously, in November of 2018, 7 men were found guilty as the ones who carried out the crime. In this trial, the company itself was exposed as having been behind the decision to eliminate Berta because of her opposition to the dam. The family's attorneys, who were able to participate in the trial as private accusers or private prosecutors, put on evidence showing the superior criminal structure that implicated executives and directors of the company, as well as state actors. There was an active military intelligence officer who basically directed the assassins, and Roberto David Castillo himself was a former military intelligence officer and a graduate of West Point. While this is an important victory for exposing the truth behind the crime and holding a powerful actor accountable, like all human rights struggles, it is only a beginning. But the fierce and courageous struggle of the family, principally the daughters of Berta Cáceres, of the Lenca organization COPIN, of Rio Blanco, and the intense solidarity around that struggle has brought about an eruption of something new in the history of Honduras and human rights. These social actors have opened up a fault line in the structures of impunity. They have defined a new horizon for human rights, for holding corporations responsible. They have created new jurisprudence in Honduras and effected change in at least some policies of international lenders. This was achieved in the courts of a system largely designed and deployed to deny their rights. It shows that critical human rights practice that understands the direction of transformative change can actually influence and impact oppressive structures in a way that leads us closer to the human rights horizon. At this point, I want to just end by sharing my screen with you and sharing some pictures. So let me see if I can do the share screen function. Yes, here it is. Here we are with my students in Rio Blanco, in the community of Rio Blanco, taking testimony of the community members of the aggressions against them and to kind of document their use and occupation of the land where they sought to construct the dam. The young woman in the hat there is Berta Zúñiga Cáceres, the daughter of Berta Cáceres. This is actually another community called La Jarcia, whose homes were destroyed because a bogus landowner came in and went to a court and said he actually owned the land, and therefore he got an eviction order from a judge to evict the family. They fought that, they got the land back, they've rebuilt their homes, not on the original home site, but in the same communal territory. This is our students with Antonia is a woman from Pahuiles. She was arrested because they set up an encampment right there where we were at to block machinery from going up and continuing to contaminate the river that they get their drinking water from. She was, I think, 7.5 months pregnant when she was jailed for 48 hours, pregnant with that little boy right there. This is one of my students, Aaron, in Rio Blanco, where we were traveling the boundaries of the territory with the GPS and kind of documenting the extent of their use and occupation of the land. This again is Pahuiles, the community there at the encampment. This is a Garifuna group. Garifuna is an Afro-descendant group on the northern coast of Honduras. We help them in their research on the human rights violations in Garifuna communities. It's apparently one of the communities that have been most subject to human rights violation because their communal lands are on very coveted beachfront property. And they just last year, 4 members of this community where we were at, Triunfo de la Cruz, were forcibly disappeared. But none of those who are shown here, just so that you know. Part of our field trip included meetings with the UN High Commissioner for Human Rights Office in Honduras. That's who was then the Human Rights Commissioner, Maria Soledad Pozo. We were there for one piece of the prior trial in Berta Cáceres, the sentencing hearing for the first 7 individuals who were convicted. So we observed that. You can see the military, it was heavily militarized, the court itself. That's the Supreme Court building and the court building in the background. This is in the community of Pahuiles, where we also took testimonies. This is with Copin. Once again, there's Berta Zúñiga Cáceres at their training center called Utopia. This is in La Jarcia, the community that was rebuilt after they were evicted. That's a sideways picture of one of my students shucking corn with community members in Rio Blanco, also in Rio Blanco. And this is the sacred river Gualcarque, the Rio Gualcarque that Berta Cáceres defended under the Lenca spirituality. The rivers have their own personality or spirit, the feminine spirit. And Berta said, you know, that the river will speak for me if I die. So these are images of the Rio Gualcarque. That's the territory of Rio Blanco, the Rio Gualcarque. And then this shows the beginning of the construction where they were stripping the forest from the mountainside, which caused landslides to go into the river. And eventually, if the project is completed, it's going to divert the river into the turbines and basically leave the part of the river that goes through the territory of Rio Blanco essentially dry for much of the year. So I'll end it there. Stop sharing. and am open to taking your questions. I hope we still have time. I hope I didn't go over time, Amy and Lauren.
Yeah, it's all good right now. So everyone, if you have any questions, please drop it into the chat or send them directly to me and Lauren through private messaging. And yeah, we could start the Q&A, and I think we'll have to end off the entire keynote at around 3:10.
How has the shift from inquisitorial to adversarial systems furthered human rights in Latin America? This is a great question, someone who's knowledgeable. As she mentions, the civil law system, criminal justice system traditionally was inquisitorial, where a judge would lead both the investigation and fact-finding of the case. And more recent reforms have made it more of a hybrid system and more adversarial as a means of establishing the truth, finding the truth, and then the tribunal as the fact finder and also the decider of the law in the case. I think what was most significant in Honduras was something that kind of is more peculiar to those systems that have this hybrid system now. But one of the elements that they have is this figure of acusador privado, of private prosecutors. It's a form of victims' rights that allows the victims, it's especially important in these cases of grave serious human rights violations, that the victims be able to participate in the trial as a party in the trial. In other words, they can put on witnesses, they can cross-examine witnesses, they can make arguments. And I don't want to go too deep into this because there's other questions coming up, but this was really significant. In the first trial of the 7 assassins, kind of material authors, as they're called, the ones who actually carried out the crime, the family members and their attorneys were excluded from the trial. There was a dispute with the judge and with the public prosecutor's office for not turning over information to them, and the judge refusing to sanction them. And so the family's attorneys asked the judges to recuse themselves. In the midst of that, the judges went on with the trial. The attorneys questioned the jurisdiction. They said, we have an amparo, a challenge pending at the Supreme Court. They missed a hearing date, even though they notified the court why they felt that the court didn't have jurisdiction, and the court excluded them from the rest of the trial. So that trial went on with a very contentious relationship between the victims and their attorneys and the public prosecutor and the court. In this case, it was the same judge panel, the same court that heard the case, and the same, of course, public prosecutors, but perhaps with different personnel. But there was a much better working arrangement. And the importance of this is that where structures of impunity exist in legal systems like Honduras, where judges themselves are threatened, the victims, if they have the capacity and they have a legal team like they had here, can play an important role in keeping the whole case on track. And one of the important outcomes of this case was really to show that while David Castillo was guilty as a co-author of the crime, he was part of a broader structure. And that evidence was presented by expert witnesses, which the family presented. Overall, I think the systems are becoming accustomed to the adversarial method. There's downsides to the adversarial method as a way of getting at the truth, but particularly the ability of the victims to participate in these processes opens up the door for shedding light on the facts. Sorry for that lengthy answer, but it was a great question, and we should go to some of the other questions now. There are a lot of female homicides in Honduras. Yes. Did the environment influence some of the women you worked with to still speak out in court, despite having the risk of negative attention that could have led to another incident? Great question. Yes, the women who testified are courageous women, but they also are they're subject to similar defamation in the media along very patriarchal lines. And it was interesting. Another significant, I've highlighted the expert who exposed the criminal structure of the company and state actors. But the other important expert witness that the family put on was Berta Sul, an indigenous Mayan sociologist from Guatemala, who studied who presented evidence on the context of aggression against Berta, which was clearly gender focused or gender marked. One of the theories which the defense even now tried to present of the case was that this was a crime of passion, that somehow Berta had been in a relationship and her partner was jealous, etc. A typical kind of gender marked trope to distract. It was brought up early on. It was one of the first lines which supposedly the public ministry investigators were going to investigate, but it was quickly discarded. It was denounced by the family as ridiculous, and because of the pressure that the family and others were putting on that I mentioned early on in the case, it kind of got the investigation on track to look at DESA, the company, and the actors in that company. So yes, the femicide, in fact, it was the family's attorneys characterized this as a femicide, Berta's assassination. Another case I worked on, it's in the Inter-American Commission, is Margarita Murillo, another peasant organizer who we also presented that. It's never been solved. So we took the case to the Inter-American Commission with our partners in Honduras, the Foro de Mujeres, the Women's Forum there, as well as a legal organization. And we characterized it as a femicide. But they're amazing, courageous women. Berta, that slight woman you saw there is amazingly fierce and courageous woman. Let's see. How do you think, thank you so much. How do you think that having a Master's of Divinity has shaped your relationship with human rights law and the career in general? I am, as a personal question, in which I accept and appreciate, I am proud of my roots within the Jesuits. Some of you may or may not know of their history. Although at the same time, I'm aware that I kind of represent types that have been very traumatic and damaging to the histories of indigenous peoples in the Americas, because I'm a former priest. I am an anthropologist, studied anthropology, an anthropologist, and a lawyer. And those three roles have not always come off well in relationship with indigenous peoples. But there's also good that comes out of each of those backgrounds that I have. In the Jesuits, is where my passion for social justice kind of was born. So my Master's of Divinity, I think, helps me in the sense, insofar as communities also identify and are motivated in their struggle for social justice through religious motivation. It's, I guess, a part of my spirituality, but it's not a significant part of my identity. I don't carry on as a theologian anymore, or at this point in my life or career. I am distanced from the Catholic Church, but some of the principles and values that I think are, in fact, kind of universal, and there's a common pool underneath all of deep and true spiritualities that I think is unified at a deeper level for all of us. Excuse me. Let's see, did I miss any questions, Lauren? Or very nice comments from some of you. Thank you so much for your comments on the talk, on my bringing in critical race theory, one of the comments.
I think someone asked if you could go over the definitions of movement law and movement lawyers.
Yeah, it's a colleague of mine, Scott Cummings. I mean, I'm at an institution at UCLA where the scholars, I am not like on the scholar side of UCLA. I am on the practice side in the clinical program and with the Promise Institute for Human Rights. But a colleague of mine, Scott Cummings, has written extensively about it with a number of case examples. You know, I think, you know, I could write about the cause of Berra as a case example of this, of how different tools were mobilized. The Fight for 15 here in LA with National Day Labor Organizing Network, lawyers kind of working with those kind of movements, with the immigrant rights movement, basically are accompanying those movements and, you know, working out strategies with the community activists that combine legal action, policy work, direct action, organizing, media, communications work. So it's, I think the main takeaways there are that the lawyers are not necessarily, probably shouldn't be the leaders of these movements, but rather accompanying these movements with the skills that we bring as lawyers. So in some cases, strategic litigation is a part of that strategy, but it's one part. And that's clear in the case with Berta's cause in Honduras. I mean, the legal team is trying to punching all the pressure points that it can, you know, with cases in domestic courts, cases in the international forum, but the grassroots organizations are also engaged in direct actions, the setting up of these camps to try to block the heavy machinery from passing through their communal lands, to stop construction. They're having mobilizations to the presidential palace and sit downs with the presidents at one point to try to negotiate solutions and to assert their rights. So I guess in terms of the theory and practice of movement lawyering, it's all about aligning with struggles that incorporate different forms of struggle and different forms of action. And the legal aspect is one important aspect, but not the only one, and sometimes not the most important one for affecting change. Well, I think we're almost at about time, it looks like. I don't know.
I think we have time for one more question. And I guess you can choose which one you want to answer.
Oh, I see, I'm getting down to the bottom here. Well, I know this might sound inappropriate, but if you're talking about human rights, why aren't you talking about ongoing torture in Turkish prisons and pregnant women in prison and also kidnapped in the third world countries? That I am the absence of that was not a sign that that I don't acknowledge that reality. My area of expertise is in the Americas, and even within the Americas, I have a particular expertise in kind of Mexico and Central America. And so my focus on human rights, you notice I didn't touch the UN system, because we have a regional system that is a pretty good forum, but there are different treaty bodies in the UN system where kind of complaints could be brought. And obviously the human rights movement, which doesn't necessarily involve litigation or complaints on these bodies, but simply is campaigns to mobilize awareness of, grave human rights violations. The pattern of human rights violations against women, the gender-based component of human rights violations, is present all over the world. And I have a good colleague, Professor Aslavali, who's on sabbatical now, or who's on loan. She's going to Colombia, but she was our director of the Promise Institute, and she is very involved. We've helped a little piece of assistance or recognition of that reality in Turkey is our support of scholars at risk, where we have supported scholars who have been forced to leave Turkey because of the threats against their lives. I also have good friends here at the university who are members of the Kurdish community. So, and the issue of Kurdish human rights is not unlike some of the issues of indigenous rights that I deal with in states in Latin America. So thank you for your question. And the fact that I didn't mention that is obviously because part of it is not my area of expertise, and you can't cover all of the types of human rights violations in a short presentation like this, where my focus was to share a bit of my experience in the projects that I have going in Honduras and to a lesser extent here in California.
All right, I think that's all the time that we have for today. Thank you so much, Mr. Berra, for that interesting keynote about the impact of international human rights law and how it has an impact on those in Honduras and your experiences, of course. And for those insightful responses to all the questions that we had today.
Thank you, everyone. Thank you. Really a pleasure. All the best to you.
Thank you.
Thank you.